Hello, my true crime lovelies. How are you? Happy Monday. I'm recording this on Monday, August 26th. When I edit it, it'll be a whole other thing. But just so you know, I was watching the docket because Sarah should have filed her response to the digital discovery that the state provided to her. If she had any objections, she was meant to provide them on the 23rd. But then I realized if she mailed it, they're not going to get it that fast. And I was also hoping to see the IMS report, but then I thought, after 5 is when they have to turn it in, so it probably won't show up till tomorrow. So while I was waiting and not realizing that, I was digging up some other stuff. I posted a video about her first 2 attorneys and a little bit of the discovery, but I want to go into more. So we're going to cover 3 things in this video, long story long. We're going to cover Blackouts, Brian Boone, and early discovery. I will give all of the dates. LW, I saw your note about the dates. These are all going to be from the first year of that early discovery. And we're going to kind of chip away at Sarah's assertion that she hasn't seen any of this. And then we're going to give her a point because there's something interesting about the jail laptop. And I was able to confirm it is the jail's laptop. Some of you guys were like, maybe it's the investigators, maybe they only have one, etc. So we're going to cover all of that in this video. So grab your drink, grab your something to munch on. Let's get into it. First, I want to cover Blackouts. I was on Reddit, as I want to do, and reading a post. And I realized some people don't know what an alcoholic blackout is, right? And God bless you. That means you've never experienced it. I unfortunately have a very sordid past and I have experienced it. So I'm just going to tell you about my experience being blackout drunk. You are still walking, talking, you can film things, eating, going to the bathroom, having sex, all of that. It's just that you won't remember it, that you did all those things later. Trust me, I've had videos in my phone, which is why when people are like, Sarah forgot she had the videos, the memory, the idea of what was happening never transferred to her long-term memory, right? It was happening in the moment. So she had the short term so she could continue to interact, right? She wasn't like, oh my God, what just happened? So she could continue to interact, but it didn't move over to her long-term memory. So when she woke up, she had no memory of it. So when people are like, how can she remember bits and pieces of it? Sometimes that is how blackouts work. There are times that in my own past, I mean, just full disclosure, where I had to piece my night together by my receipts. Like I would not remember how I got from point A to point B. I wasn't driving, I was in New York. So it was like looking at Uber receipts or looking at Lyft receipts, looking at restaurants I have been to, bars I have been to. It's bad, guys. It's really bad. I don't recommend it. But I feel just based on the way she was speaking and the way she recalls, she does not remember all of it. Now, I can't say which parts are blacked out and which parts are fabricated, but I am 100% sure she had no memory of recording those videos. And she was like completely drunk, even though she wants to say, oh, I'll blame it on the wine. It doesn't mean I was drunk. Because in that one part, she was like telling him, wiggle a little. I want to get it on video. And then she was like, what did she say? Something crazy. I'm not going to play the video because it just sickens me. But when she's telling him wiggle a little bit, he's begging for his life. And she's like, wiggle a little bit. I want to get it on film, or I want to get it on video. I think she says extra or whatever. She has no memory of any of that. But she only knows that she went upstairs because that's where she woke up, right? So she was like, oh, I went to bed a little bit. Like she doesn't remember that she called Brian. So I think it was in the phone like 11:45. He doesn't remember what she said because he was like, it's late. And she's, he could tell she had been drinking. So she didn't remember that part to tell it either, right? So that is blackout drunk. And I mean, there are times my little one is making noises over there, and I'm trying out a new headset, so hopefully I sound clear. I know I had like clicking noises last time. I was using an external trackpad on my MacBook, so hopefully this sound will come out clear. I'm working on it, guys. I'm new with all of this part of it. I used to do like vlogs and whatnot. So Yeah, so the blackout, I mean, there are times, and then you can also pass out where you are fully asleep. So I think she was blackout drunk, and then she went upstairs, hung up with Brian, and then she passed out, and then she woke up in the morning trying to piece things together. She's looking for George, like she wakes up at noon or whatever, and when she's like, "Oh, I got up and then I laid there," I don't think that is the case. Like I feel like she probably got up to go to the bathroom and laid back down, like she was laying in the bed doing what, contemplating what, like she's hungover, right? And so when she was finally able to get up, she's gonna go look for, she wants to smoke a cigarette, maybe some coffee, some Dr. Pepper, whatever. I mean, you can, oh my God, I can't believe I'm putting this on the internet. You can be blackout drunk to the point where you could be having sex and then you pass out during sex and you have no memory that you're even having sex. Saying for a friend. So that is what I think happened there. Okay, now I want to go into Brian because on my last video that just posted, I was saying how Padilla was not paid for by Brian. It's iffy if he paid for the retainer, but for sure, Padilla filed with the court sworn testimony, notarized sworn, that he was working pro bono. So let's just get into Brian because he did not lose the house. And Sarah weighed in on it. Of course she did, right? So I just want to show you a couple of the things that I found. Let's just share. Can you guys see me? This. Okay. Is that where I want it to be? No. Let me find the right document. Okay. So this was filed 10/19/2022, right? Final disposition form. And this is regarding the mortgage on the home where Brian and Lucas live. In the Circuit Court of the Ninth Judicial Circuit in and for Orange County, Florida, Federal Home Loan Mortgage Corporation as trustee for the benefit of the Freddie Mac Seasoned Credit Risk Transfer Trust. So I believe he was already in trouble financially, and so then it got moved over to this because there was something in here from Citibank as well. But I'm not in real estate, so you guys may know better than I do. I'm just saying my 2 cents. Amount of final judgment. Please indicate the amount of the final judgment, rounded to the nearest dollar. 0. Means of final disposition. So was it, you have all these options: dismissed before hearing, dismissed after hearing, disposed by default, like if no one responded, disposed by judge, where judge ruled like, hey, this is what it's going to be. You know, it was a bench trial. Disposed by non-jury trial. So, which I would think that would be judge, but again, not a lawyer, not a realtor. Disposed by jury trial. And then other is what they have marked here. And it's 10/18/22. And then we go to this one. So plaintiffs notice of voluntary dismissal without prejudice and discharge of lis pendens. Probably butchered that. So come now, the plaintiff, Federal Home Loan Mortgage Corporation, as trustee for the benefit of the Freddie Mac Seasoned Credit Risk Transfer Trust, by and through its undersigned counsel and Florida Rule of Civil Procedure 1.420, voluntarily dismisses this case without prejudice. All counts of the complaint against defendants Brian C. Boone, aka Brian Boone, Sarah K. Boone, aka Sarah Boone, unknown spouse of Brian C. Boone, aka Brian Boone, State of Florida, Clerk of the Court. I'm skipping down here. Said dismissal serves as a discharge of the lis pendens filed in the public records of Orange County, Florida, in the above styled matter regarding the below described property. So basically, they dismissed it without prejudice. Without prejudice means they can bring this back again if for whatever reason. So they probably have made some sort of payment arrangement or agreement. And so they're closing out the case so that it's not hanging over. But if something should happen again, they are free to start another lawsuit, right? If it was dismissed with prejudice, they can never bring that back again. So he did not lose the house, and that was the last one filed. Now he is in credit card debt, but who isn't? So someone filed against him. It's under, I think it's under 15,000. Well, I'm not going to go into that. This is what I want to show you because I saw this and I was like, oh, that handwriting looks like Sarah's. And of course it is. To whom it may concern, I am writing in regards to a summons I received on 9/27/22. So she was in jail at that point. So I'm guessing Brian said, if you need to reach her, this is where it is, but you ain't heard it from me.
I received on 9/27/22 for federal home loan mortgage versus Brian C. Boone et al. My name is also included. I am not underscore involved, included, or interested in any of the foreclosure proceedings or dealings with this lawsuit. I am divorced from Brian C. Boone and have been since 2017. In our marriage dissolution agreement, I signed my rights and underscore name were removed, all caps, from said mortgage. I have not lived in the house, and not is underscored, located at blah, blah, blah since the divorce, nor paid or contributed in any way toward this mortgage.
Lord. There's so much I could say, but we have no doubt that she hasn't paid or contributed in any way to the mortgage.
My name and all underscore affiliation was released, making me no party to this now and future.
Sarah, you were no party long before any judicial proceedings.
After speaking to former husband regarding receiving this summons, I was told everything is taken care of and will be up to date on Monday, October 3rd, 2022. He underscore is the one working on whatever needs to be done for the account to be current and or correct. Again, I have nothing to do with this. Or, however, former husband Brian C. Boone and the mortgage company are handling. Please remove my name so I am no longer included in this matter. In the meantime, my former husband stated he is contacting the court and mortgage company to provide the aforementioned information so they can send confirmation letters stating my removal from this and everything therein. Thank you for your cooperation. Please send notification my letter as being received so I am aware the court, etc., is aware of my timely response. Should any questions or concerns arise, please let me know. Sarah Boone.
And this heifer wrote this from the jail and put the jail. I mean, I guess she has to put it on there. But wow, balls of a burglar. Balls of a burglar, right? For those of you guys who came over from Kathy's Gossip, Rumor, and Innuendo, if you haven't been over there, I highly suggest you get over there. But I need that shirt. Heifer what? Because that was a heifer what. So that is that with Brian and the mortgage. He hasn't lost the house. Presumably, based on the court filings, he's keeping up with his payments. The last thing was, this was, like I said, in 2022. The one before that, he had in 2018, which was the year, I think, after their divorce, because they got divorced in 2017. Yeah. 2017 is when they got divorced. So there was something in 2018. But the fact that this is going on and this woman is writing to the judge in the other case, which they locked me out of that, or not me personally, but it's sealed, which makes sense. I mean, there's children involved or a child involved. But she's asking for her $1,000 a month alimony while she is in jail, and he is solo parenting. I mean, she wasn't contributing financially before, but at least if he had something to do, he could do it while Lucas was with his mom. Now, I mean, I don't know if he has to pay for a sitter. You know what I'm saying? He's all alone taking care of the child, emotionally, financially, physically, spiritually, mentally, and you're bothering him about sending you $1,000 while you're in jail. What could you anyway, you guys get it. Just balls of a burglar. I just don't understand her chutzpah. I don't even know if it's chutzpah, because I feel like chutzpah is you have gumption. Hers is just foolishness and chicanery. F&C. I don't understand her F&C. I don't. Shouldn't you be focused on your child, ma'am? Okay, so that is that. Now I'm going to go into her day one attorney, because I touched on him a little bit. So not the one who was on there for literally a day, but the one who came on day two, Mauricio Padilla. So I have his website up. So Padilla Law Group is what he is a part of. The website is MIA, the airport, the Miami Airport, International Airport. ESQ, like Esquire, MIAESQ.com, litigating some of the nation's toughest cases. Offices in Miami, Oficina un, I don't know what that is, something in Puerto Rico. Speak to us today. High profile cases. Mauricio Padilla has litigated some of the most complex murder cases in the nation. He represented Dedrick Williams in the 11-week homicide trial of, I think it's Triple X Tentacion in Broward County. I have a little clip for you.
You ask yourself, how could that be? If any of us is involved in, God forbid, in a murder, and you say, hey, it's so-and-so, you better believe so-and-so is going to get investigated. But in this case, they didn't do it. They didn't do it because it didn't comport with their version and their narrative. And as law enforcement, I think that they have the obligation to do so.
So he's passionate. He tried the state of Florida versus Derek Medina, a case that garnered international media attention because the defendant posted a picture of the decedent to Facebook. Wow, I did not see that, but goodness gracious. I mean, what about the decedent's family, Mr. Padilla also represented Sigfredo Garcia in Leon County. Mr. Garcia was charged with the murder of Dan Markel. I would dare to say maybe he did this pro bono also for the publicity, right? He's a high profile guy. I don't know. What was the guy who represented Casey Anthony and now is representing the Stamp It Up woman? Oh my God, I can see his face. You guys will tell me in the comments. But it's giving that kind of like he's striving for that type of status. Experience matters. Someone fighting for you. Call today. The goal of Padilla Law Group is always to provide quality legal advice and counsel through a personalized attorney-client relationship. As a service-oriented law firm, the goals of the client and their concerns are always a top priority. Let me say it again. The goals of clients and their concerns are always a top priority. So that is who Sarah had. And he wasn't good enough. And he stuck with her for 2 years, like right before trial, he bailed out. And he couldn't disclose it because he said it would be basically against her best interest. So he was ethical. We only can imagine what. So let's look now at the discovery that he brought in, that he requested, and which kind of blows Sarah's little...
I haven't seen my discovery. I haven't seen any of it. I'm just getting it.
Out of the water. Because he was very thorough and he started asking for discovery in March of 2020. Bankowitz was no slouch either. I may do a video on that. We'll see if I have time. Okay, this is what we're looking at. Second degree murder, February 23rd is when the offense happened. And it was 10 days after his birthday. His birthday is February 13th. He was his mother's Valentine present back in 1978. So he had just turned 42. When she took his life. In the last video, we went through her indigency and insolvency, so we'll skip past that. Okay, we're on the Orange County Clerk website here. Lydia L. Labar comes now the state of Florida through the undersigned Assistant State Attorney, pursuant to defendant's notice of intent to participate in discovery in Florida rule. So this is from the state. See attached witness list. This list of witnesses is not necessarily limited to those named, but also includes any witnesses mentioned in any material made available for defendant's discovery. Undersigned Assistant State Attorney has initialed yes below for each subparagraph listing items in the state's possession or control. Statements given by persons, yes. Written, recorded, and or oral statements of defendant, yes. Written, recorded, and or oral statements of co-defendants, none. Recorded grand jury testimony of defendant, none. Why? Because there's no co-defendants and there was no grand jury called for this. Tangible papers or objects obtained from or belonging to defendant, yes. Material or information provided by any confidential informants, none. I would expect those to be like in drug cases. Electronic surveillance of premises of defendant or of conversations to which defendant was a party, yes. So yeah. Documents pertaining to any search or seizure, Yes. Reports or statements of experts. Yes. Tangible papers or objects not obtained from or belonging to defendant, which the state intends to use at hearing or trial. Yes. Tangible papers, objects, or substances in the possession of law enforcement that could be tested for DNA. Yes. It was, oh my God, what did they take? Well, the suitcase, the necktie, the bat, the pillowcases. For sure. Material or information that has been provided by an informant witness? No. Document will serve as authorization for the said above addressee, the attorney for the defendant, or the defendant's designated representative to conduct discovery of tangible objects in the above style cause. So there's a lot of legalese here, but they're responding to Mauricio Padilla file something saying we intend to participate in discovery. So that was their first response to that. There we go. I'm getting the hang of it. You get a bunch of supplemental discovery, answer to demand for discovery. We went over this in the prior video. Motion to appoint expert. This is what I really want to dig into. So this is dated October 27th, 2022. Amended notice of discovery for digital media. Comes now the state of Florida by and through the undersigned ASA and hereby places the defendant on notice. Ooh, not placing her on notice that digital media evidence such as body camera videos was previously disclosed in this case, and defense was sent a download link to download the digital evidence from evidence.com. You have to have a code to get in because I tried, y'all. Please note that some videos may contain geolocating information that may not be visible in the downloaded videos. If you would like to review the videos in the state's possession, please contact the assigned assistant state attorney. So now notice I said this is 22. We were looking at 20, right? So this is when she has Blackouts as an attorney at that point. So she sent him on a fool's errand because they're saying, listen, we already gave this to you, but you're asking for it. She doesn't know what happened to it, right? And I don't know, like, the way she asserts things, this is my 2 cents. I have not spoken to Sarah. I have not spoken to Blackouts. The way she asserts things, I'm inferring that she told him we never got these. So he asked, Blackouts asked, and the state is like, no, we gave these to you, and you can find them at evidence.com. They each have like a code, so he would just be able to put that code in and see it for the case. That was that. But I want to give her a bone. And we'll say April of 2022, we've gone back. Amended motion to allow computer. Am I sharing? No, I'm not. Say hi. You say hi. Hi. Okay, amended motion to allow computer forensic expert to bring into Orange County Jail expert's computer. Comes now the defendant, Sarah Boone, by and through undersigned counsel who files this motion to allow, oh my goodness. Okay, we're about to come off. So he just came in here, got up on the bed, turned the TV back on. Who is in charge in this house? It is not me. It is not me. Third time's a charm. Let's see. Comes now the defendant, Sarah Boone, by and through undersigned counsel who files this motion to allow computer forensic expert to bring into Orange County Jail expert's computer and as grounds, therefore, would state. So they're saying they want this expert, the forensic expert, to come in with their own computer, right? The defendant is charged in the above captioned matter with the offense of second-degree murder. The defendant is currently housed in Orange County Jail. Orange County Jail policy requires any electronic files to be brought in on a USB flash drive and viewed on the jail's computer. So that is the policy, because I would know one of you guys say, well, what if it's the investigator's laptop or she was trained on that laptop? There's nothing on there that she can use except the USB that's plugged in, right? So there's no programs, there's none of that. It's just a simple Dell Latitude 650 or 6530. Provided by the jail. So, and that laptop has the operating system locked down to prevent the installation of any software. Depending on where you work, like I work for a major corporation, our laptops are locked down. You can't willy-nilly just start installing stuff because it could expose the corporate network to malware. The cell phone report created by the Orange County Sheriff's Office is in Cellbrite's proprietary UFDR format and requires the use of the Cellbrite UFDR viewer, right? So Bright probably charges you for that. They want to get their money. I'm not mad. So because they can't install anything, including this viewer on that jail laptop, she can't see the full Cellbrite report. In addition, the report includes attached pictures in Apple's proprietary HEIC format and videos in H.264 QuickTime format, as they were extracted from defendant's iPhone. Those files cannot be viewed on the jail's computer without additional software and are critical to Miss Boone's defense. So we know we're talking about images on her iPhone. 2 videos and the one still photo for sure of the night she had George in the suitcase. Wherefore, the defendant hereby requests the court issue an order requiring the Orange County Jail to allow the defendant's appointed computer forensic expert, John Savicki, to bring a computer with the appropriate software installed into the jail to allow the defendant to review necessary discovery materials, including the Cellbrite report and attached pictures and videos. Mr. Savicki is a former law enforcement officer and a member of the Florida State Bar. Yes, call out your credentials. And will maintain close control of the equipment. And I think they could have an officer in the room to make sure they're not doing anything nefarious, right, on the court system. So I thought that was interesting. I'm gonna look and see if that order was granted. Okay, this is an amended motion to allow computer. Let's see if we can see the difference. So that does not look like it was responded to, because then we go subpoena for deposition, subpoena for deposition. But here on the 18th, he files a motion to withdraw. So yeah, Padilla files this. Undersigned has been forced to move to withdraw. This motion is made in good faith for the reasons stated above. Undersigned is forced to withdraw as irreconcilable differences have arisen between undersigned and the defendant that have made it impossible for undersigned to effectively represent his client. As always, it is difficult to convey all particulars to the court and at the same time maintain all duties to the client. So that's the other part. Like, you know, she is free to say whatever she wants about any of these attorneys, whether it be the truth or not, because the truth ain't in her. Sarah and the truth don't know each other. And they can't say anything in retaliation. So I feel like in her histrionic, dramatic, escalating state, she likes to put things out there to get a reaction, right? It gets more and more dramatic. I feel like I had that as a child. If my mom didn't respond to something, then I would just be more like emphatic about it. So she says these nasty things about them and they can't respond because of the confidentiality, right? So she can say, oh, they lie. They can't say, no, I didn't. So it's just like disrespectful, but that feels like an understatement. So yeah, so they never responded. There was never an order about seeing these documents or digital files for that. So I wonder, because we haven't heard anything about that during this time, but I do remember it was either Mr. J or Chicken Cacciatore who said they have trouble with some of the files. All the more reason why those 9 files she should have opened immediately, because I know they said one of them was the suitcase one because they renamed it from like suitcase video to something else. Like Cacciatore stood up and said that. So I need to go back and watch that hearing. He withdraws on the 29th, or his withdrawal is granted, and then here comes Sarah, I think. Well, this is weird because here it says the motion to withdraw was granted, but then here's another motion to withdraw. Oh, this is what Kranick mentioned, the second amended. And he says, undersigned's relationship with defendant has become adversarial. The aforementioned adversarial relationship has interfered with undersigned counsel's ability to effectively represent his client, especially preparing for trial. So he's probably in there trying to coach her because I'm sure she wants to, oh, I did it again. I'm sure she wants to testify. So he's probably trying to coach her for trial, right? And she's often Never Neverland or Sarah Land. Undersigned relationships with the defendant has deteriorated to a point where undersigned counsel can no longer give effective aid in the fair representation of Ms. Boone's defense. This motion is in compliance, blah, blah, blah. Rules regulating the Florida bar are present, or whether the attorney-client relationship has deteriorated to a point where counsel can no longer give effective aid in the fair presentation of a defense. Appreciates the court providing him the opportunity to amend his previously filed motion. However, after further researching the issue, undersigned is still under the belief that the specifics of the adversarial relationship may disclose information that may prejudice his client. As such, will stand mute on the specifics. Yeah, so probably telling the judge my client is cuckoo for Cocoa Puffs and thinks she's walking out and won't participate fully is something he can't disclose to the judge. It might be prejudicial. I got you. Oh, Sarah. Oh my goodness. It's a lot, you guys. It's a lot. I am losing my voice, so I'm going to wrap it up there. But hopefully, you know, those little tidbits were helpful. Brian's house is okay. Blackout drunk is a thing where you don't remember, but you're still walking and talking. And who Mauricio Padilla is and what he did for Miss Sarah. It's such a mess. It's such a mess. All of these delays. I feel like she is, at this point, I do feel like she's intentionally delaying it. Like at first I didn't. I just thought maybe she was struggling a little bit, but I think she's intentionally delaying it. And so I think it's totally unfair to Georgia's family, Georgia's parents, especially. My brother was killed in 2001. I've said that before, and then I thought, oh, the trial was in 2006. It actually was in 2007. My aunt died in 2006. My sister and I had surgery in 2006, and then that was a trial. So my mom was going through all sorts of things because it was like her favorite sister. I know you're not supposed to say that, but y'all don't know my mom and her sisters. And it was like, it was just piled on and piled on. So the longer it takes, and as a family, you don't know what's going on. Like at that point, I wasn't following true crime like I am now. I had no way of like looking at the motion. I mean, I had a way. I didn't have the forethought, research that out, because you wonder like what is taking so long, right? And it was what, six years for us, and now this family, the Torres family, is going on almost 5 years, and so it just is like, let's get it over with. I'm tired of all her demands and staples and extra smalls, and she needs an office and the internet. Although I did see because I've been scouring their website, they're rolling out an email plan on that smart tablet that they have access to. So eventually they will have emails, but by that time I'm hoping Sarah will be in prison and she could have whatever it is they get in prison. All right, let me not go down that rabbit hole with you guys. So hopefully this clears up some things. Thank you for hanging out. I'm almost at 1,000. So if you haven't subscribed yet and you like the content, please subscribe. Come and hang out with us for a while. Like, comment, please let me know. I want to hear your 2 cents in the comments below. I'll see you down there. All right. Bye.